This guy is so generous to spend time with us every Thursday. He's the former federal prosecutor who weighs in on any number of legal issues. Now he works the defense side of the table. And if you haven't heard David Katz argue the defense for any number of people or issues that you might think undefendable, then you haven't treated yourself to a real David Katz session. It's amazing. He's weighed in on Trump. He's weighed in on the Supreme Court. And he'll give us the real story on so many of these issues. How about it for David Katz, everybody? Hello,
Great
sir.
to be with you guys.
So, David, first, we'll start with the Trump stuff, get it out of the way, and then I want to get to what I think is a bigger issue with the Supreme Court case. The Trump re-gagging of Donald Trump, I wonder if you could just speak to that quickly. Kim touched on it in the news.
Well, I have a bit of a cold today, so bear with me. If you have any trouble hearing, let me know.
Okay, thank you.
By the way, Kissinger left in 1938 from Germany.
Okay, all right.
And Kristallnacht was later that year. And actually, my father was a refugee, and his family left in early 39. But he left when he was younger, so my dad never had that accent. His family was so fortunate to be able to go to the United Kingdom, and he had a British accent, which I wish I had.
Wow.
I wish I had affected it, because when the Beatles came along, I had the haircut, but I didn't have the British accent to impress the girls. Anyway, you were asking about Trump. Well, this was sort of obvious. Trump can be gagged when it comes to criticizing the court staff. And, the backstory of this, people say it's the First Amendment. Why can't he comment? He doesn't like the court clerk. But the reality was you have to balance the harms in First Amendment analysis. It's not an absolute right, Mark, any more than the Second Amendment is an absolute right. And they were getting death threats, by the dozens or by the hundreds, both the law clerk and the judge. And the judge could say, well, I'm sitting here in a black robe and I signed up for this. But, my law clerk or staff, they really haven't. And I think that the Court of Appeal balanced that in New York and reimposed the gag order. He can make certain criticisms, of course, and he can still criticize the judge on his case and say that it's unfair, that he's being prosecuted, he's being singled out. But he cannot attack under the reimposed gag order by the Court of Appeals. He can't impose the court's law clerk and the court staff. And I think that's kind of par for the course.
Well, she was noting, not to interrupt, David, but just to put a finer point on it, Kim was noting that, these staffers who are working this case, they're getting death threats and their phones are blowing up from this.
Yeah, and that just has to be, with the level of communications now and with the fact that, one person, 1,000, that's all it takes. And she's gotten, apparently, and other court staff have gotten hundreds, if not thousands, of threats. And of course, a lot of them are meaningless. Nobody would like to get them. But I think that that's important. Can I comment on the other thing? There's been a sort of a news flash that Trump has transferred $40 million. And that has an interesting backstory. And can we talk about that?
No, exactly. That's what we wanted to. I think it's on our, isn't it? It's on our front page. So please, yes.
Well, the story is that Trump, in my opinion, figured, why ask for permission ahead? Just do it. And then you can kind of, muddle through some explanations. And I think he got away with it because I think the reality is if he had gone to the court monitor and said to her, look, or said to her staff, I'm going to transfer $40 million. I'm going to pay $29 million of my income taxes out of it. I'm going to pay $5 million to E. Jean Carroll for the sex assault civil suit that she won against him. His alternative would have been to post an appeal bond for about $5 million. I'm sure Trump thought it was cheaper to do it the way he did it than to do the appeal bond. There's probably a fee, right? Mark, let's say they charge you 20% to post that bond. He said, I'd rather pay the 5 than the 6. And that the judge might have gone along with, or the judge's monitor might have gone along with and said, look, you got to pay her. And sure, that's a way to pay her 5 instead of 6. That actually preserves the Trump organization estate. But there's $29 million. There might have been a lot of questions. And he also paid a lawyer a whole bunch of money. And, if you're a court-appointed lawyer in the federal courts, they scrutinize your bill up one side and down the other. They may not scrutinize the defense budget of $1 trillion, but they sure scrutinize those kinds of bills. I think that this monitor would have scrutinized that bill. But what he did is he just paid it. But the way that it came up we found out about it, Mark, and that's why it was a breaking news story. But the way it actually came up is that Trump has had her there. The monitor is a former federal district judge. She's retired, and now she does this. She's paid to do this, to be the court appointed monitor, Barbara Jones. She and her staff go over to Trump Tower on Fifth Avenue. They set up a room over there where they can look into all of these things that they're supposed to be monitoring. While they're there monitoring them, the judge didn't allow this, but Trump wanted to call her, and I think her chief accountant, bean counter, to the stand to say, we've been monitoring Trump for a year. By the way, they opposed, like the Dickens, there being a monitor, the Trump organization, and Trump's lawyer did. But they lost. A court monitor was put in there. She's over at Trump Tower. They wanted to call her and a member of her staff to the stand to say, he didn't do anything wrong. There was no fraud during all this period of time. I may have been charged with committing fraud before this, but once we had a monitor, I didn't commit any fraud. You know what I mean? I robbed 3 banks, but later in the afternoon, I drove by another bank and I didn't rob it. That's like really, really. So the judge said, he said 2 things. He said, I'm surprised that you, the prosecution, are objecting because actually the evidence is going to break your way if I had allowed her to testify. But no, there's no precedent for this. So I'm not going to allow her or her accountant to testify to this, the monitor. But here's what's interesting. In the course of that, the other side, the prosecution, said, you know what? The report actually says that, no, this was not blame-free this year. What he actually did is he transferred $40 million without ever getting her approval, and he had to get her approval ahead of time. We've now made it clear to the Trump organization and Trump's lawyers that all transactions means all transactions. Mark, it's unbelievable. Apparently, the Trump organization, all their smart lawyers, including the $3 million man that Trump hired, didn't understand that you must get clearance for all transactions above $5 million. Really meant you have to get pre-clearance for all transactions above $5 million. But then we explained to them that that all means all, and now the monitor is satisfied that what Trump is doing is okay. So the reality is he's not going to be held in contempt. From the point of view of any other person in court, he got away with it. If you didn't do what you were supposed to do with a court-ordered monitor, you think they'd come down on you like a ton of bricks. But no, Trump got away with this one. Now he understands that when you transfer $29 million, you have to ask the monitor first. Of course, the fear is that he's dissipating the assets, right? At some point, he'll ask for a tax refund of $12 million, right? This is Trump. And what did he do? He just got $12 million out of the Trump organization ahead of a $250 million fine, right, Mark? That's what's going to play out. He's paid more tax than he could have. He could have challenged it. The monitor could have made a big deal about it. He overpaid his taxes, and then he's going to claw back that money later on, and there'll be nothing that this civil judge can do about it. So it's all very frustrating, but there it is.
Wow, that is really interesting. It's a fiendish way, as you say, to dissipate that pot of gold that is being adjudicated right now, right? I mean, the fine could be way more than $250 million, as you've noted before.
Well, people have trouble understanding the posture of that case. It's fraud, but it's not criminal fraud. It's civil fraud. That's why they were able to call to the stand Trump and his sons. Now, in the defense case, Trump and his sons are going to take the stand in the defense case, in their own case. So we're going to see his sons and him again for a second time. Supposedly, he's going to be the parting shot witness. We're expecting him around December 11th, Monday, December 11th. We think will be the last witness in the defense case, civil case. And we think that'll be Trump. And we don't know yet whether the prosecutor will then put on a rebuttal case. They're allowed to put on a rebuttal case if it truly rebuts what's been put on in the defense case. So we're going to wait and see. But that's where we seem to be in that case.
I was looking to see if there was any question before I get to this big thing, which is going on at Supreme Court level. We've already addressed this, Michael. It maybe new. The 14th Amendment. It doesn't appear to those judges have kind of kicked that can down the way. So I'd like to move on to this SCOTUS case. That's all the Trump stuff. The Supreme Court case is, I think it's significant. I've been talking about this for a long time, since the right wing really took control of the court. The notion somehow, and you can characterize some of the specifics here, and also please correct me if I'm wrong, but the notion somehow that the court can rule that certain government agencies and government regulatory bodies don't have the constitutional underpinnings they don't, to be able to carry out a lot of the regulation and a lot of the watching over and regulation of so many things from business to the environment that these agencies are charged with. So in that way, they can dismantle this, quote, administrative state and it's an extremely business-friendly court, as you've made the point before. David, can you speak to how this case can kick the door open to that?
Well, yes, this is the Securities and Exchange Commission against actually a radio talk show host of about 15 years ago. And what this radio talk show host did was he used his radio show as a way to, induce investments, as a lot of these, especially right-wing radio shows do. They talk about the economy is collapsing. You got to get into gold. Of course, the gold investment they want you to get into is the one that they're controlling. And he managed to get about $25 million from what I would call his dupes. And the SEC went after him because it was a security, which is regulated by federal law and by the Securities and Exchange Commission. And if you want to have an interstate market in securities, you have to register with the Securities and Exchange Commission, and you have to obey its rules. He was found by the SEC not to have obeyed its rules, to have done wrong. And so they fined him $300,000, and they said he should make restitution of over $500,000, and they barred him from the securities industry. Now, as to barring him from the securities industry and as to the disgorgement, those are not affected in any way, shape, or form by the Seventh Amendment. The Seventh Amendment to our Constitution says that in suits at common law, the right to jury trial must be preserved, or the right to a jury must be preserved. Now, 100 years ago, and this goes back to when the New Deal happened, Mark, we had all these agencies set up because we were in the Great Depression. And when they set up these agencies, let me just give you an example. You could find somebody to work for you for 50 cents an hour, but the federal government imposed a law that said you have to pay $1 an hour. There's a minimum wage law. And they set up a board, a federal board, that made sure that you paid the minimum wage. If you went in there and got caught, it wasn't enough to just have to pay the minimum wage. You got fined, okay, by the federal agency. The argument was made back then that this violated the Seventh Amendment, that you were not getting a jury trial, that if a person came after you individually and said, I want my back wages, and I want you to be fined like triple damages or something, you'd have a jury trial. But with this federal agency to make sure that you were getting paid enough, no, you didn't get a jury trial, even if you were trying to get money, even if you were trying to get a fine. So as the Supreme Court just said yesterday, or one of the justices said, if you don't pay the money, let's take that out of it. If somebody sues you civilly for money, there's a jury trial. If the government sues you for money, why isn't there a jury trial? And of course, the simple answer is that this was decided 100 years ago. Then it was decided 50 years ago. And so that was why Justice Kagan, who's one of the moderate to liberals on the Supreme Court, said, and the lawyer said, well, for 50 years, nobody's raised it. For 50 years, no one's challenged it. But I am now. And that's, you should get rid of that old precedent. Of course, he had ways to try to worm around the precedent, but he said, you're basically getting rid of an old precedent. She said, no one's had the chutzpah to challenge it for 50 years. And this to me is a little bit like Dobbs, It's something where this is like a little Dobbs, a little like the end of Roe v. Wade, where they take something that's a very clear precedent, and the idea that you should have a jury trial on all these regulatory actions, it's just not, doesn't make sense to anybody. This is sort of a Hail Mary, but this part of the Hail Mary seems to have landed, and it looks like the Supreme Court is going to do something. They said to the lawyer for this person who was found liable for stock manipulation and violations, they said to his lawyer, what exactly do you want us to do? And it sounded like what he said was that, I guess the disgorgement would stand, and maybe being barred from the industry would stand, but the fine would not stand up, Mark, because he should have had a jury trial on this. And people are just sort of, they're just astonished by all of this, and especially the fact that Roberts seems to have questions about it. People are stunned that like Chief Justice Roberts had the questions that he had. Now, the Fifth Circuit down there decided this case. The Fifth Circuit's the now become the excuse me, the bane of the federal system. Everybody files suit down in Texas, Mississippi, or Louisiana. They go up to the Fifth Circuit. This case was decided 2-1. Guess who the two were? Members of the Federalist Society, one of them appointed by Trump, one of the two, one of them a former law clerk for Sam Alito on the Supreme Court. And they had two more radical ideas, even in this jury trial thing. They also said, by the way, there's a unitary executive, and so the president ought to have the power to fire administrative law judges in the Securities and Exchange Commission, which, if that's true, which the Fifth Circuit held, they can also be fired, the administrative law judges of the EPA, any agency that you could think of, a federal agency. The good news is that the U.S. Supreme Court seemed to treat that as just dead on arrival, that they are not interested in that. But the people who are really scared think, okay, somehow Trump wins the presidency. He's railing against the deep state. The deep state includes these administrative agencies that protect our health, our safety, our food, our environment. And then there's going to be judges he doesn't like. He can just fire them because they're actually executive officials. Anyway, luckily, the Supreme Court wasn't interested in that at all. And the second thing is that they do take a lot of their cases, these federal agencies, to the federal courts. If they take them to the federal courts, that's all fine. But some of the cases they keep in-house, and people need to understand this if they think, well, this is the deep state, this is so unfair. The government would not work. If this actually ever becomes law, they would blow up the government. They would blow up the EPA. They would actually blow up, here's what's interesting, they'd blow up ICE. You know, a lot of people are deported, right, from an agency. What, they all get a jury trial if they're fined any amount of money? That would be great. And the thing is, look at Social Security, Mark. Social Security generates 500,000 cases a year. So this is all Federalist Society, debating society BS, because there's no way that you could have a federal trial on these cases. 500,000 Social Security cases a year. You're going to try with our limited number of United States district judges? I think there's 1,000 in the country, 1,100 in the country. You're going to try 500,000 cases just from the Social Security. So this is blowing up the government. But what they say is that there needs to be more discretion if you send it to one court or you take it inside the agency.
That's fascinating. And it's interesting that you can go after the government and the, quote, administrative state. I mean, like Steve Bannon really was doing the dirty work for Trump when he was first taking office. That is to say, Trump was, and Bannon was in there doing a lot of the heavy lifting of justice, et cetera. But the idea somehow that you could encumber the government, you could make it so ridiculously, as you say, weighted down with these jury trials that it just becomes ridiculous, that you have no government anymore. It's a fascinating thing. The stuff that I had read about and have been talking about since Trump took office and we had this right-wing court was associated with essentially invalidating a lot of these agencies. This is another tactic to invalidate them, sort of, isn't it?
Well, it is, and there's another thing. I don't want to bore all your listeners, but this is really the nitty-gritty. I looked at today's newspaper, the LA Times. I don't think it even ran this story. But this story is so important for the impact on America. We cannot function without these administrative agencies. And we can't function without these administrative law judges. Now, they are not partisan. To become an SEC judge or a tax court judge is a big, big deal. To become an INS judge, like to adjudicate these asylum claims. These are all a big deal. These are very distinguished lawyers who get these judgeships in these agencies. They are removed from the agency itself. I mean, the glib answer is, wow, they're both prosecutor and judge. Well, there's a part of the agency at the IRS, there's a part of the agency at the FTC, the SEC, that prosecutes the case. But there is this core of objective, merit-based, very learned judges who sit on them. And they are not just some sort of hacks or something. And yet, of course, if some friend of Trump didn't like the way the case was going, they would pressure that administrative law judge and they could get rid of the administrative law judge. At the risk of boring your listeners, because I think this really is the nitty gritty, you hear about Chevron deference and people's eyes glaze over. What is Chevron deference? That case is about to come up in January, and it's part of this ongoing effort by the right wing. Rich people, huge corporations, that's who a lot of these agencies go after, okay? And if you had a tenth as much enforcement if you had muddled enforcement, who does it help? It doesn't help the consumers. It doesn't help the people who have to live in the messed up environment that we have to live in with all the stock swindles that are going on. It doesn't help the average investor. It doesn't help the average person living in a crappy environment. It helps the people who make the crappy environment, the big companies, the super rich who profit from it. That is the reality. So here we have the Congress passes. This is Chevron deference case that's coming up in January. This is the fishing boats. Now, you remember all of the people, and I certainly agreed with them, talked about that boat that was off the coast of California, where over 20 people died for lack of a watch because of lack of regulation. So when people say, I don't want to live in a regulated country, I want to be a libertarian. You really want to be a libertarian when it comes to nobody inspected and made sure that that boat that over 20 people died on was safe? Here's the case in January. It involves fishing boats. The Congress says we want the government to regulate and inspect fishing boats to make sure they're safe. They don't say exactly how they're going to pay for it. So the agency that's in charge says, well, we'll have the fishing boat operators pay for it. That seems pretty logical. The Chevron deference is that if it sort of makes sense what the agency did, reading the statute, that's okay. The challenge in the Supreme Court says, no, we fishing boat operators don't have to pay for the federal regulators who come on our ships because it wasn't expressly stated in the statute. And so if they don't have the Chevron deference, they're going to go through with a fine-tooth comb and say things like, the federal government should inspect ships, but since they didn't say exactly how to pay for it, any scheme that costs the operators of fishing boats money is not proper, even though Congress passed that law. This is abrogating the Congress. This is not the separation of powers that we have in mind. Congress passed that bill. It's awfully hard to pass bills in Congress. Look at the filibusters, look at everything else. To say that you have to make it especially clear. And that's also finally the major case doctrine, where they say, this was last term, where they say if it's really major and it really makes a difference, Congress has to be really clear. Well, if it's clear, it's clear. They interpret a statute, it's clear. What do you mean? There's certain kind of cases where it has to be really, really clear. Mark, that's just an excuse for the right-wingers on the court not to go with federal regulations that have been passed by Congress, the federal regulatory schemes that have been passed by Congress. And everything would come to a halt if you didn't have these administrative agencies and these ALJs.
That's exactly it, isn't it? So
Yes.
what a transformational year this could be in all the bad ways. As you say, when it comes to food safety, environmental safety, regulating poisons in the environment, when it comes to consumer protections and banking, and it's just so wide-reaching, the destruction that could be wrought. It's remarkable.
It's reminiscent really of the New Deal that we weren't around for, but this is so history repeating itself, and not good history, because this is what FDR ran into. The country was in terrible shape. There were reforms that were really needed. He expanded the size of the federal government. And when he did, a very conservative Supreme Court pushed back and said things like on the minimum wage and on agricultural support prices, because the farmers were losing everything. They said, there's the Commerce Clause. It doesn't allow that. Look at the big government. Big government's pushing its way into everything. And then there was the famous, a switch in time, save 9. So I'm hoping there'll be a switch in time, saves 9. On this one, I think Kavanaugh may be okay. I was very surprised by some of Robert's questions. We're really going to have to see. There's still the other case with the Consumer Product Safety Commission, which I think is going to come out right. We did that one about a month ago. So when you add the whole thing together, what it may be, Mark, if you look on the bright side would be that when an agency, and it will only apply to the SEC, people argue it applies to all these federal agencies, 35 of them, like we talked about, 35 different federal agencies, Social Security, immigration, the FTC, everything. But this ruling may only be that if they want to get a fine out of you, they have to give you a jury trial. So in a case that really hinges on a fine, they'll have to take those cases to federal court, not do them inside the agency. By the way, people think it's inside the agency. Oh my God, once the agency screws you, you stayed screwed forever. No, look at this guy. He went to the Fifth Circuit Court of Appeals. He didn't get screwed forever. He went to the Fifth Circuit Court of Appeals and he complained about everything all over the country. if you get screwed by one of these agencies, you can go to the Court of Appeals. The idea is that they've already adjudicated it. They've already had a trial-like proceeding. So you don't get to go many times to the trial court. You go straight to the Court of Appeals. But the idea that you're screwed forever and you have no remedy, you do have a remedy. So I'm with the moderates, the liberals on these cases. I don't think any of these arguments amount to a hill of beans. I think they were all decided 50 years ago, and they're binding precedents. And I think it's a lot of chutzpah, a lot of gall to go back and make these idiotic arguments. But they don't. They weren't treated like idiotic arguments by at least 5 justices on the Supreme Court in this hearing yesterday.
Yeah, exactly. The hearing was yesterday. I'm so glad you said it. This is the SEC versus this, talk radio guy who was shoveling, get rich stuff. But it's scary. We'll watch it. And you're right. It's been ignored by the mainstream media. It's crazy. Anyway, David, I love our time together. Thank you. Now, will I get another visit with David or not, Kim? I don't think I will. Is that right? This is his last. Somebody wake Kim. I'm
awake.
All right. Okay.
Yes. No. This is it for you and David Katz for the month of December. David, it'll be you and me because Mark is he's decided that he'd rather go on a cruise than do his show.
That is so not true.
Kim, how are you?
She's making fun of me because she knows I don't want to go. I really don't, and I'm being forced into it because I've got to keep my marriage together.
Yeah, he's going on a 3-month-long cruise. It's going to be fantastic.
It's just the rest of December. It's going to seem like 3 months, but it's not.
He's going to be gambling and eating aboard a ship and lounging by the pool and playing shuffleboard.
I'd be willing to bet my lunch that there's alcohol involved.
But that means I got a David Katz date for 3 weeks in December, unless you're going somewhere too.
I don't want to pick the things I'll miss the most, but top 3 for sure, David Katz, really. Yeah. I mean it. David, we adore you on the show.
Happy New Year, Mark. Yeah. Happy New Year. Enjoy the cruise, and it'll be great to be with you, Kim. We go way back to Pat Thurston, don't we?
That's right. Yes,
That's right. You guys, it'll be a reunion. So, David Katz, you're awesome. David Katz, everybody. Happy holidays, pal. See you. Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.